Good morning. My name is Amanda Brissot and I'm General Manager of the Western Sydney Business Connection, and I'd like to welcome you to today's webinar, COVID-19 in the Workplace, presented in partnership with Platinum Partner, Matthews Folbigg Lawyers. Before we commence, I would like to acknowledge the traditional owners of the land that we're meeting on today, wherever that may be for you. I'm on the land of the Darug and the Guringai people, and I acknowledge them as the traditional owners of the land on which I reside and recognise their continuing connection to land, water and culture. I pay my respects to elders past, present and emerging, and to any Aboriginal people that we have online today. Welcome. I would like to thank our Platinum partners for their continued support of WSBC and the program that we're able to deliver to our members and beyond. That includes Campbelltown City Council, Commonwealth Bank, City of Parramatta, Efficiency Works, Institute of Strategic Management, Matthews Folbigg Lawyers, NEC Australia and Parramatta Leagues Club. Oh, and world-class teams, beg pardon. Well, COVID and COVID-19 restrictions have placed enormous strain on businesses and individuals alike. Not only are we required to manage our own businesses in a very tough economic climate while homeschooling, we must also stay abreast of the ever-changing landscape resulting from the pandemic. You know, what restrictions are in place, you know, vaccinations versus not vaccination. You know, there's just so much that we need to stay across. And it's exhausting and it's difficult. So we're really pleased to have Matthews Folbigg law firm here with us today to share some of their insights and some of their knowledge with us to at least help clarify some parts of that sort of very confusing landscape. So the way that we will work this morning is first we will hear from Jeff Brown. Excuse me. Jeff is the chairman of Matthews Folbigg Lawyers and principal in the Insolvency, Restructuring and Debt Recovery Group. We will also be hearing from Chinthana Malalasakera. He's a lawyer in the Matthews Folbigg Workplace Solutions Employment Law Team. So welcome to Jeff and Chinthana. Thanks for joining us today. So to kick off today, I might hand over to Jeff and we'll see you shortly. As per usual, please feel free to ask any questions that you have in the question box down the bottom. And if you could use question rather than chat, that just makes it a little bit easier for us to process, particularly if there are a lot of questions. As I said, once we've heard from Jeff, we will stop at that point and answer questions that you have of Jeff, and then we'll move on to Chinthana and answer questions at the end. So over to you, Jeff.
Thank you very much, Amanda. Good morning, and good morning to all of you out there, attendees in the webinar, both members of the Western Sydney Business Connection and other registrants. Thanks very much for taking some time out today to hear a couple of perspectives from us about the COVID crisis. Obviously, we have had to hide behind a rock to successfully ignore the COVID crisis. It greets us when we get home every day, and that's assuming we've been able to leave our homes. It is there when we wake up in the morning, and it dominates our TV screen. So we are trying to look at a couple of perspectives that are a little bit off centre. We think nonetheless they are very important. Chinthana will be speaking about one particular quite crucial aspect of workplace relations law and the obligation, if one exists, to vaccinate. I will be looking at COVID through the prism of a creditor who's owed a business debt, or a debtor who owes a business debt. How is life different for them, and how will it look in the next 6 months, 12 months, 2 years? In doing that, what I don't propose to do is talk about the better known responses that the government has brought to bear on those issues. So I'm talking about the huge injection of cash that the government has put behind the various job relief and job seeker schemes, and also the various very well documented relief packages for landlords and tenants. So I'll be not so much focusing on those. I think they've been very well discussed in other forums. I'll be looking at two measures, principally, that the government set out to achieve without too much publicity at the start of the COVID crisis. Put as simply as possible, and I don't proposed to go through the letter of the law today, you'll be relieved to know. The government, at the beginning of the COVID crisis, decided that it would be a policy priority for them to make it harder for people to collect debt and make it easier for debtors to voluntarily restructure their debt. So I'll look at each of those in turn. I'll look at the way the government did that. I'll assess whether or not what they've done has been a success, and then I hope to focus at the end on what the future holds so far as the world of credit and debt is concerned. So let's talk about how the government made it a little bit more difficult to collect debt. I might just get a slide change if that's okay. Beautiful. First of all, the government increased the minimum amount of debt that a creditor could use to base a creditor's statutory demand or a bankruptcy notice upon. Now, those two documents are the precursors, respectively, to someone being able to wind up a company or place it in liquidation, or in the case of a bankruptcy notice, to make someone declared bankrupt by a court. So by increasing those thresholds, the amount of the debt that you could successfully have and still base your recovery activities on winding up or bankruptcy, they sought to dramatically reduce the number of people going bankrupt and the number of companies going into liquidation during the start of the COVID crisis. So they did that by originally increasing the minimum amount you could base an application to wind up a company from $2,000 to $20,000. And in the case of bankruptcy, they also increased the minimum amount to $20,000. Now, they've subsequently been reduced, although not to the original levels. Now the minimum level in respect of a winding up is $4,000. And in the case of bankruptcy, it's $10,000. So they really were some fairly major levers. To add to that, those that have ever gone down that avenue, or and I hope it's not the case, or have ever faced either one of those avenues, will know that when you commence debt recovery proceedings in this way, there is a time allowed for the debtor to comply with the demand for payment. And that was traditionally a period of 3 weeks. Now, that was extended, again, under the same package of reforms, to 6 months. So even if you received one of these documents and therefore your debt was more than those increased minimum amounts, you still had 6 months to respond. So they were really the two major levers under the heading of let's make it harder for people to collect debt that the government sought to bring into play, with the obvious aim of seeking to put a sensible cap on what might otherwise have been a flood of insolvencies and windings up and bankruptcies. In terms of making it easier for the debtors themselves to restructure their debt, there were also a number of levers. They were very broadly placed under the banner of simplifying the process of attempting to restructure your debt as a precursor or as an alternate step to having to go into liquidation or to be wound up as a company. The basic tenet of those reforms was a restructuring plan, which was designed to be a very user-friendly document that a debtor could create and effectively put to creditors as a proposal for dealing with their debt. If enough creditors supported that arrangement, then under this simplified process, without the need for in-person meetings, a person called a small business restructuring practitioner who is assisting the company can put the proposal to creditors and pass it. That would avoid the company going into liquidation and hopefully get the company back on track particularly once the COVID conditions started to ease. Other measures included an availability open to directors to develop restructuring strategies when their company is in a distressed situation, without the concern that by doing so, they are effectively allowing their company to trade whilst insolvent. So those current laws, which make it a personal liability on directors to go on trading while their company's insolvent, were significantly relaxed. And as part of that, what we call a safe harbour was created for directors. Anecdotal evidence suggests that that wasn't taken up in huge numbers, and we'll talk about the broader reaction to these reforms in a moment. The final limb in terms of restructuring was to greatly simplify the liquidation process. So what the government sought to do in certain circumstances was remove all the meetings of creditors, remove the obligations on liquidators to constantly report back to the creditors of the company in writing, and there would be only one distribution of a dividend to creditors. Again, this is to make an orderly winding up of the company a realistic option for a director, so something that's not nearly as expensive as it traditionally has been. We've often faced the ironic situation that someone can't actually afford to appoint a liquidator to their company. This was an attempt to address that. Okay, so if we can move on to the next slide, you will see that I now want to have a look at which parts of that worked and which parts of it didn't work. You'll recall I began with the government's attempts to increase the threshold for creditors to begin winding up companies, and to stagger out the time frame for creditors to comply with demands. In terms of addressing the number of companies that went into liquidation as a result of receiving a demand, it has to be said these reforms were spectacularly successful. The number of windings up that took place in the September and December 2020 quarters, according to ASIC, were down between 32 and 60% from the corresponding quarters in the previous year. So a very noticeable, very statistically significant drop-off in the number of companies that were going into liquidation. And that is undoubtedly a direct link to these laws coming into play. Most creditors who would threaten as part of their credit collection policies and then act on the winding up of companies were effectively abandoning that tactic during the last really 18 months. I would put inverted commas around the word success, though. I mean, if you're just looking at the numbers of companies that actually got wound up, they obviously fell off a cliff, and those numbers are very much down. But I'm sure you will appreciate there is a very significant and important difference between the numbers of companies that are being wound up and the numbers of companies that are actually broke. And I will discuss later on the impact of it being very difficult to wind up companies that are undoubtedly in irretrievable financial difficulty. Moving to the debt restructuring reforms, that's the ability to be able to work with a practitioner to effectively come up with a restructuring plan for creditors. They have been a failure. I don't think anybody can seriously debate that there's been a massive failure of adoption of those reforms. A number of reasons for that have to do with the requirements. They are only open to companies with debts of less than $1 million. That includes related party debts, so that if the company owes the directors money because the directors have put capital into the company or have loaned money to the company, then that obviously needs to be added to get to your $1 million. It is not open to companies who have any employee entitlements owing of any sort. And that is another reason why, unfortunately, many companies that are facing distress haven't been able to use this program because, unfortunately, one of the debts that have grown are things like their obligation to pay super or to meet other employee-related obligations. To give you some idea of the extent of the failure, statistics show that in June 2021, across Australia, 5 companies used the debt restructuring process. In July 21, it was 4. And in case you are thinking that might just be a statistical blip, last month it was only 6. So we're tracking along the bottom, unfortunately, and there is negligible take-up of these reforms. The simplified liquidation process, which again was an attempt to make life easier for people to decide to go into liquidation, has also, I think, been a failure. Similar to the debt restructuring reforms, you could only have a debt or debts of less than $1 million. Significantly, all your tax reporting had to be up to date. Now, I, as you know from the introduction, work in this area. I'm not aware of a great many debtors who see things seriously enough to come to a lawyer or an accountant for help with their business who doesn't owe some tax or hasn't failed to put their tax reporting completely up to date. Missing BASs and missing returns are commonplace. And unfortunately, if that's the case, it shuts the door on these reforms. You only need 25% of creditors to, for whatever reason, dislike the simplified process and prefer the old-fashioned process for it to be scuttled. And we're hearing from liquidators that it is often the case, because they're having to field, nevertheless, questions from creditors once the simplified process has begun, that the price difference in doing a simplified wind-up to a normal, if I can put it that way, wind-up is not great. It costs about the same. So, look, at best a mixed bag. The government has tried to pull a few levers there, but I would argue they've had very much negligible impact when compared to the bigger picture reforms like pumping money into the economy. I might just get the next slide, if that's okay. All right, let's just talk about what we might see on the horizon. Now, really, I think what's driving that is going to be the nation's largest creditor, which is the Taxation Office. Now, where do we currently stand with the Tax Office addressing its own debt? In June 2021, the Australian Taxation Office across Australia lodged 1 winding up application. In July, they lodged another one. And in August, in a massive blip, they lodged 4. So when you compare that to previous years' figures pre-COVID, which were normally around about the 120 to 130 mark per month winding up applications, it's clear the ATO, in terms of its big sticks, winding up companies and so forth, they have really turned the tap off. There is more or less a moratorium on that sort of seriously delinquent debt type activity. The ATO has closed up shop so far as that is concerned. In fact, not only with winding up companies, but really with virtually any of their formal debt collection processes. And that's been the case for about 12 months. That's just a reflection of trends generally. Across the board, creditors have followed suit, and there really just aren't many windings up going on from month to month. We can speculate on exactly why that is so. I think there's really two factors going on here. One is that there has been, until quite recently, enough government money swishing around the economy to prop up businesses that would, in other circumstances, perhaps have made the decision not to carry on. Those companies are also benefiting from the fact that where they do owe money to private individuals, they've been able to work within the changed rules that make it very difficult for you to lodge an application to to wind up a company or bankrupt someone, those measures I discussed at the beginning of my presentation. The other quite simple reason, in my view, it's at least from what I have heard from clients and contacts, is in the current circumstances, in some sectors, things are so bad there's really not much point in winding up companies. It is not going to bring to focus a pile of assets which could be made available to creditors. In certain sectors, the effects of COVID have been so great that government support is really the only source of income. And as soon as that is turned off, which of course would take place if a company's wound up, there are no assets. So there is little incentive on a creditor to take that step. To a large extent, that includes the ATO. And on top of that, I think is a public interest motivation coming probably from government to not be going hard so far as the ATO and other government revenue bodies are concerned on debt, not to be seen to be giving with one hand and taking with the other. Look, that's probably provided some short-term relief and some short-term answers to some short-term problems in a macroeconomic sense, but it has created an enormous backlog of ATO debt. I think these trends are more or less going to be seen as similar across the public sector landscape. So what's true for the ATO is probably true for state government revenue agencies like Revenue New South Wales. But if we look at the ATO as an example, the Financial Review reported back in 30 June this year that the year-on-year increase in ATO debt was the largest that had been seen over the past 4 years. According to the ATO's own annual report, ATO debt for the financial year 2020 sat at $34.1 billion. Now, for those fond of interesting but ultimately useless statistics, that figure, $34.1 billion, if it was GDP, would put the ATO in the top 100 nations on earth. So it's a big sum of money. It is also what the ATO call collectible debt. So it is debt that has gone past its due collection date, but it is not subject to any objection by the taxpayer. So it has entered the ATO's normal system for recovering delinquent debt, which normally begins with a reminder letter or something of that nature. So there's $34.1 billion sitting under that broad category. Now, look at that in the context of overall government debt, bearing in mind that government looks to ATO collections in order to be able to prop up its expenditure and keep its balance of payments at a sensible level. There have been many commentaries about what's happening to the deficit, but just to summarise, net Commonwealth government debt has grown from zero at 2008, 2009, and expected to reach about $729 billion by the end of the current financial year. That's about 34% of GDP. It's expected to peak at the end of financial year 2025 at about $981 billion. That's obviously close enough to $1 trillion debt. The other moving part, government expenditure, it shows no sign of slowing down. Both sides of Parliament are announcing and have announced strategies to continue spending, particularly on infrastructure and on various social welfare policies to help spend us out and then through the COVID crisis. Some of those it is possible to see as ultimately revenue positive. Building infrastructure obviously is something that can add to the efficiencies of the economy. There's plenty of other expenditures in areas like childcare and aged care, which are extremely important from a social point of view, but don't add quite as much to overall government revenue, even in an indirect sense. So what do we see in the future? Well, look, there will be a day, believe it or not, when COVID is not on the front page of every newspaper, and COVID is not the first thing you hear when you turn on your radio or your television, or you check news websites. COVID, we will either learn to live with it and get sick of hearing about it, or we will effectively deal with it, or, as most people suspect, it'll be a combination of both. When that happens, and it will happen, and it is, I think, starting to happen, the ATO will begin again its process of a return to situation normal, which is a reasonably aggressive debt collection policy. That was certainly the trend we were seeing before COVID had hit. The ATO and other revenue agencies had taken quite a number of steps to strengthen and streamline their debt collection processes before COVID. And certainly they will be looking to instigate those streamlined policies once I think the public interest imperative to hold off on debt collection is removed. So the other thing important with the largest creditor in Australia ramping up its activities is that it has an important flow-on effect. Generally, what happens is the number of applications for windings up, bankruptcies and that sort of thing across the board is likely to increase. So what does all of this mean to you? Well, let's start by looking at creditors. What does it mean if you are a creditor? Well, it means that debtor companies and individuals, those that owe you money, are going to come under increasing pressure to either address their debt or to go into some sort of external administration, liquidation, bankruptcy, winding up, that sort of thing. You need to start the process now of reviewing your debtors and getting the real story as carefully as possible. That's not the same as demanding payment. What it is trying to figure out how big the problem, if there is a problem, you actually have with your creditors. So assessing not only the age of the debt, but the creditworthiness of the debtor themselves. All of that is with a view to getting yourself ahead of the curve. I think the time is coming very soon when prudent creditors are going to resume what is close to their normal debt collection processes. Now, what I should indicate at this stage is, in anticipation of that, we at Matthews Folbigg are offering to all registrants to this particular seminar an opportunity to consult with us in relation to their key debts and work together towards creating a letter of demand, which is the normal first step, I suppose you would say, towards the process of what I would call formal debt recovery attempts. It is important to get that letter right, and it's very important that that letter reflects your circumstances and is not a boilerplate document that can go out every single time. If it's not intelligently drafted, in my experience, they quite often get ignored. So we are certainly offering to all registrants who have logged on to this seminar an opportunity to contact us free of charge to discuss how to create that document, again free of charge, and also more generally to discuss their debt collection strategies. Now, the other thing you can be doing certainly is keeping a close eye on what the ATO is doing, because as I've said, they're an important leader. Both the ASIC and the ATO publish statistics monthly as to what they are doing in this space, and they're easily available on the web on either the ATO or the Securities Investments Commission website. It's not something I would do every day as I was eating my cornflakes, but it certainly is something I would keep a reasonably close eye on to see if those activities are being ramped up. I would also consider what steps I could take to secure any debt that I have that is presently not secured. So that could be as simple as including a clause in your normal trading terms that gives you the opportunity to charge your debt with security. It could be formally lodging a security. It could be taking out caveats or mortgages or those sorts of things. Now, that is a difficult discussion to have, particularly with a customer who's been with you for a long time. Again, we are happy to consult with you on ways to do that. And of course, more than happy to talk to you about the technical process of becoming a secured creditor. If you are a debtor, my advice very finally and very concisely is to get in quickly. Whether it's the ATO, and particularly, I guess, if it is the ATO, or whether it's someone else you owe money to, I would be getting in front of them now, and I would be putting together a carefully thought out and detailed proposal for payment. If it is the ATO you're dealing with, then my experience is what they will take a very dim light to is you not contacting them, allowing debt to grow without instigating contact with the ATO. It's obviously important to get that contact, however, right. And it needs to be positive in tone. I always recommend people in that situation work with professionals to develop a business plan that is realistic, that is based on real numbers. And if it does mean that you're asking the ATO to somehow compromise its debt, it demonstrates why that's necessary. I would suggest that now, but for not much longer, is about the best time to be reaching out to the ATO. I know from experience with clients, they are actively listening for ways to help business, and they are acting in a supportive way, formally and informally. That isn't always the case, as some people know, and so the time to bite the bullet, if I can put it that way, is now. Please, if you are a debtor, can I urge you to be realistic about the next 12 months. If you're in a position you think to be able to recover from whatever difficulties COVID has created for you, then start the process of restructuring your debt, reaching out to your creditors and trying to work with them. Importantly, though, if on a realistic assessment you are not in a position to trade on, it is dangerous in ways I couldn't begin to describe in the time I've got for you to stick your head in the sand. So please obtain advice as to how to address that problem if it's irretrievable. Act quickly and act decisively. Thank you for your time. That is really all I wanted to outline today. I would welcome any questions.
Thanks, Jeff, for that presentation. It certainly sounds like the conversation will be shifting very soon to one that focuses heavily on debt and recovering debt. We do have one question. We are a little bit over time, so we're going to just have the time for the one question from Andrew. What percentage of businesses are estimated to be financially distressed due to the government response to COVID at the moment? Do you have any insights on that?
Yeah, look, the short answer is I wish I knew. It is very easy in a statistical sense for businesses to conceal whether they are insolvent as the law understands it. And that is simply that they can't pay their debts as and when they fall due. The best, I think, source of information for that sort of statistic would be either a credit reference agency who regularly runs statistics on these things, or the Australian Institute of Credit Managers, who is the professional body that deals with the credit industry. For obvious reasons, they are both doing their very, very best to keep a careful eye on that. I would say, with the greatest of respect, even those statistics that they have produced, which show a much higher default number than the ATO statistics show, are understating it, because at the moment, with the amount of government stimulus that's floating around, it is not that difficult for companies to effectively move that money around in order to conceal the depth of their problems. So my very unscientific answer would be to take a worst case scenario and maybe add 1 or 2% to that. I think the situation is fairly dire, quite frankly.
I mean, in terms of the offer that you just mentioned, so that's complimentary to the people that are on the call to get in touch with, and you'll share some details after that. And just to confirm, we will be sharing the slides and the recording after. You'll receive that as part of the thank you letter, and some information on how to get in touch with Matthews Folbigg if you'd like some assistance. Well, thank you, Jeff. I think it's time to hand over to Chinthana. Chinthana, over to you for part 2 of the presentation.
Thank you, Amanda, and thank you, everyone. Thank you all for being here today. So I'll be speaking to you a bit about mandatory vaccines in the workplace and the rights and responsibilities of employers while navigating their contractual and policy concerns. Specifically, I'm referring to the rather hot topic of COVID-19 vaccines. There has certainly been a great debate in recent weeks surrounding this particular issue. I personally have received a number of phone calls from employees and employers alike wanting to know what their respective rights are in relation to the public health order, specifically the provisions relating to the vaccines. We are in quite clearly an unprecedented time, I think it's fair to say, with a highly transmissible, infectious, and sadly deadly virus, which has implications broader than health. The social, legal, and certainly the economic impacts are vast, and they're changing rather rapidly. With that in mind, I think it's worth placing a caveat at the beginning of this presentation. The public health orders are, for lack of a better term, a moving beast, and are likely to continue to be amended in the coming days, weeks, or months. Therefore, it is entirely possible that parts of this presentation may be updated, so it is highly important that employers consult the most recent New South Wales public health orders, or that they seek legal advice if they have any doubts pertaining to the content of the orders or the legality of their actions. That being said, let's begin by asking perhaps what is the most important questions. Are vaccines in the workplace mandatory? The answer, generally speaking, is no, they're not mandatory. In most circumstances, an employer will not be able to direct an employee to receive a COVID-19 vaccine. Now, the federal government decided that it would not make it mandatory for employers to receive a jab in order to return to work. Further guidance released by Safe Work Australia and the Fair Work Ombudsman has also emphasized that any mandatory vaccination requirements must be assessed on a case-by-case basis. There isn't a one-size-fits-all approach here. So an employer in most circumstances will not be able to direct an employee to receive a vaccine. And it is important, I would say critical for employers to keep in mind that directing an employee to get a vaccine, a COVID-19 vaccine, could result in the employee having the right to a legal remedy against the employer, for example, a discrimination claim. That being said, there are certain circumstances where an employer can direct an employee to receive a vaccine, and these include as part of a contractual term, as part of a public health order, and or as part of a lawful and reasonable direction. Now, looking at the contractual term first, it is possible for employers to insert vaccination requirements into their employment agreements. For new employees or new employment agreements being provided by employers, they could specify or they could require vaccination as a prerequisite of employment, thereby mandating the vaccine. As part of a public health order, such as the one we will be discussing shortly, it too can mandate that employees be vaccinated before returning to work. And certainly we have seen examples of that. And as part of a lawful, reasonable direction, which employers have the right to issue to their employees, and employees similarly are under an obligation to comply with such directions. Importantly, though, what is lawful and reasonable will require an examination of the relevant factual circumstances, and it is decided on context. So again, it is evaluated on a case-by-case basis. However, as a general proposition, it may be considered lawful and reasonable for employers to mandate their employees be vaccinated where there is a high level of interaction with the public, for instance, healthcare workers, where employers who provide services to a vulnerable group of people, for instance, aged care workers, and or where employers cannot facilitate other risk minimization controls. So, for example, on-site testing. Please do keep in mind that even if employers are able to direct their employees be vaccinated, these employers may still have a work health and safety obligation to consult with their employees prior to doing so. It is important that any vaccination policy be the result of extensive consultation with employees, that they've been given a fair opportunity to voice their concerns or offer any input, raise concerns about the policy, and have these concerns addressed by the employer. It is crucial, again, for employers looking to implement a mandatory vaccine policy in their workplace that they take as much time as is perhaps required to address the concerns of those who do not want to be vaccinated, and ensure that provisions or safeguards are in place for people who have legitimate reasons as to why they cannot be vaccinated. Any concerns brought by employees against vaccinations, again, should be genuinely considered, and appropriate allowances should be reflected in a policy. Now, let's assume you have a contract or approved policy that essentially allows you to mandate that your employees be vaccinated. Is it still possible for some employees to refuse? And the answer is yes. Employees can still refuse to be vaccinated on the grounds that the mandate to do so is discriminatory in nature, or because they have an exemption, such as a medical exemption, that allows them to be unvaccinated. So, considering the discrimination grounds first, just a bit of background for you. Under Australian discrimination laws, it is unlawful to treat a person less favorably on the basis of protected attributes such as gender, race, disability, or age, etc. This is referred to as direct discrimination. Now, mandating vaccines may not result in direct discrimination, as a person's decision to refuse a vaccine is not an attribute that is protected by any Australian discrimination laws. However, indirect discrimination is also prohibited by discrimination laws, and employees may be able to rely on indirect discrimination as grounds for their refusal. So, looking at what indirect discrimination is, in a nutshell, it occurs where there's a policy that applies in the same way for everybody, but unreasonably disadvantages a group of people who share a protected characteristic or attribute. As an example, think of a scenario where an individual failed to secure a position with a company because the company has a policy that all workers must have a driving license. Now, if the person has a disability that prevents them from driving, and driving is not an essential part of the job, then the requirement to obtain a driver's license is unreasonable. So with that in mind, indirect discrimination may be unlawful if some employees are less able to comply with the vaccine mandate. If, for example, they have a particular disability which prevents them from receiving the vaccine, or perhaps the policy includes a date by which they need to get vaccinated and they were unable to do so due to a vaccine shortage. Whether the mandate is considered reasonable will depend on the workplace in question and the employee's particular circumstances, such as any legitimate health risks that would prevent him or her from receiving a COVID vaccine. Employers looking to introduce a mandatory vaccine policy need to take care that they do not inadvertently, indirectly discriminate against employees. Again, as we've already said, the best way to do this is for employers to develop a policy that has had the input of the employees and has appropriate exceptions, such as persons for whom the vaccine has not been approved for use, or those with medical or other contraindications. Now, it is possible that certain employees may have pre-existing health concerns that would necessarily preclude them from receiving a vaccine. In these circumstances, they can obtain what is called a medical contraindication certificate from a medical professional, and I will be discussing what that is shortly. However, in circumstances where employees are genuinely prevented from receiving a vaccine, employees should consider whether they're able to accommodate an unvaccinated worker in their workplace, whether the employer can facilitate a periodic testing regime for the benefit of an unvaccinated worker, whether it is possible to provide an unvaccinated worker with alternative duties, whether flexible working arrangements can be arranged. Now, just with regards to flexible working arrangements, I would like to point out that under the most recent New South Wales Public Health Order, Section 4.19, an employer must require an employee whose place of residence or usual place of work is in an area of concern to work at the employee's place of residence unless it is not reasonably practicable to do so. Essentially, what this means is that an employee who is capable of performing his or her duties from home, they do not need to come into their workplace, must be allowed to do so unless there's a legitimate reason as to why they cannot. There, of course, will be some instances where an employer will need all employees to be vaccinated as an inherent requirement of the role. We see this, for example, with nurses. In certain circumstances, should an employee not adhere to the inherent requirement, then that employee may be dismissed. Again, this will need to be assessed on a case-by-case basis. Should the employee then bring a claim against the employer may be able to rely on the fact that accommodating an unvaccinated employee in its workplace causes unjustifiable hardship upon the employer. In such a circumstance, the employer may have a defense against a general protections claim or an unfair dismissal claim or an unlawful discrimination claim if the employment ceased on the basis that the employee is unvaccinated. Organizations, employers will need to ensure that they comply with all relevant obligations under the privacy laws in respect of their collection, storage, and use of information, such as information that is used for evidencing worker vaccinations or underlying medical conditions which prevent such vaccinations. If an employer is looking to record an employee's vaccination status, it will only be permissible if that recording is reasonably necessary for the employer's business activities. An employee must also be able to give their consent freely for an employer to be able to collect and store the employee's vaccination status. One exception to this is where the collection is required or authorized by law, for example, the public health order. The employer also has an obligation to inform the employee how this information will be handled, and the employer bears complete responsibility of ensuring that the information collected on an employee is kept secure and isn't mishandled in any way. Now, moving on to the New South Wales Public Health Order. The original order was published on the 20th of August, 2021, and was updated most recently on the 5th of September. Due to how rapidly the current climate changes, this public health order could see further amendments. However, the number of times it's already been amended really highlight how this area is ever evolving, and employers should seek legal advice before committing to a policy in their workplace or terminating an employee. Now, some of the key points of the public health order pertain to the rules for authorized workers to leave their LGAs, as well as travel permits. Now, on the list before you is a list of categories. Please bear in mind that within these categories are further subcategories. So it is important that you make sure your employees are or are not a part of those subcategories. Also, these categories are subject to change. So once again, it is very important that employers stay on top of the most recent New South Wales public health orders. Moving on now, per this particular public health order, authorized workers who are 16 years of age or older can only leave their LGAs of concern if they're able to satisfy one of these two requirements. Either they have to have received at least one dose of a COVID-19 vaccination, or they must have a medical contraindication certificate. As to what a medical contraindication certificate is, it is a certificate issued by a medical practitioner in a form that's approved by the Chief Health Officer, and certifying that because of a specified medical contraindication, the person to whom the certificate has been issued cannot have a COVID-19 vaccine. Now, I've included an image here of what the medical contraindication certificate is. This form can be downloaded from New South Wales Health's website by anyone who wishes to have it filled in by their doctor. The certificate must then be carried by the party to whom it was issued, and they may be asked to present it. For instance, an employer may ask an employee to provide them with their medical contraindication certificate in order to enter the workplace. Ultimately, however, unless an authorized worker is either vaccinated, either partially with having received one dose or completely, or they're in possession of a medical contraindication certificate, they will not be allowed to leave their LGAs of concern for the purpose of attending work. The most recent amendment of the public health order also introduced this provision. It allows an authorized worker to leave their LGA of concern as long as they can produce evidence that they have an appointment to receive a COVID-19 vaccine on or before the 19th of September. And this will take place from the 9th of September. The end date may be subject to further change. So again, a recurring theme of this presentation is to stay up to date as best as possible with the most recent version of the public health orders. Now, as I've previously mentioned, if an employee has not received at least one dose of the COVID-19 vaccine, and they are unable to acquire a medical contraindication certificate, they will not be able to leave their LGAs of concern. So what does this mean for them as far as their employment is concerned? Well, if an employee cannot satisfy one of the requirements, either one of the requirements, they can elect to work from home if doing so is reasonable in the circumstances. They may elect to take annual leave or long service leave, should that be an option available to them, or they can elect to take unpaid leave, again, should that be an option to them. As for employers, well, employers may wish to direct the employees to get vaccinated in order to return to the workplace. This direction is unlikely to be, or rather, this direction is likely to be lawful and reasonable, given the public health order in place. Employees can be disciplined or ultimately have their employment terminated if they are unable to work because they failed to comply with the public health order and essentially with the direction. An employer may also be able to withhold pay from an employee until they get vaccinated. This will depend on if, because of their vaccination status, the employee is unable to leave the LGA or cannot enter the workplace to commence work, and therefore there would be likely grounds to withhold pay on the basis that employees simply cannot present for work. If employees cannot present for work, the obligation to pay them may not necessarily arise. Additionally, an employer may also rely on the employee's employment contract if it contains a warranty or condition clause, which requires employees to comply with all legal requirements necessary to perform their role. This is a requirement which employees would be unable to satisfy if they do not comply with the relevant health orders. Now, if your employment contracts do not contain such clauses, it is still possible that the obligation can also be implied. There is case law which provides that an employee must be ready, willing, and able to perform work as directed. Where the employee has failed to meet the public health order requirements on vaccination, they may be unable to perform some elements of the role, which may then in turn disentitle them to payment. Travel permits, just quickly, are another requirement under the New South Wales Public Health Order. They are required in the circumstances you see on the slide, which are you're a worker living in an LGA of concern and you need to leave the LGA in order to work. You are a worker entering an LGA of concern in order to work, and you are from a non-area of concern and you need to travel more than 50 kilometers outside of Greater Sydney for work and you cannot work from home. In New South Wales, it is the employee's responsibility to register for a travel permit. They can do so by visiting the Service New South Wales website and providing the required information. As for how long a travel permit lasts, this is really dependent on the dates on which the authorized worker is traveling. If he or she is traveling for 14 days or more, the travel permit will be valid until the 30th of September, 2021. If an authorized worker currently holds a 14-day permit, it will automatically be extended to the 30th of September, and the authorized worker will not need to reapply to extend the permit. However, if the reason for travel changes or the dates change or need to be amended, a new permit will be required. And that's everything from me. Thank you very much, everybody. I will now take some questions should you have any. And I would also like to point out that for questions that require careful consideration or a lengthy explanation, you can always reach out to me after the session. My email address is on the slide before you. Hopefully you could see that clearly. But it'll be in the slides that we provide to you, for sure.
Terrific, thanks, Chinthana. We do have a couple of questions, and we are almost out of time. But the question we have here from George is: can you provide clarity on employees who provide admin duties for organisations that work in the aged or disability sector? Is this currently mandatory under the public health orders that they are vaccinated?
So, I understand that the point of the question. Are they, if they're living in LGAs of concern and they're traveling for the purpose of work, then the public health order will apply. Generally speaking, if their admin work is working in clinics or hospitals, for instance, the requirement, as far as I understand it, is that they be vaccinated or provide a medical contraindication certificate.
Got it. The next one is from in relation to teachers. So it's mandated for teachers to be vaccinated by the 8th of November. Does this also apply to independent school teachers?
That is not something I've actually considered and may warrant further consideration. My understanding, again, and please bear in mind that this is all subject to change, my understanding is that if you are in these specific industries, I know that construction, for example, has its own set of requirements as well. The mandate does apply. Certain industries may have additional requirements placed upon them. Again, this is something that the public health order will state or should state. I have not turned my mind to that question, but if you are around students, my non-scientific answer, to use Jeff's words, would be yes, you probably would need a vaccine or a medical contraindication certificate.
Thank you. And this is quite a complex one for our final question. This employer has an employee that's refusing the vaccine due to religious beliefs. They do live in an area of concern. They can't work from home. They're in security services. The employer is able to provide work for them in their area of concern. However, there is an issue that their vaccinated personnel are refusing to work with this person because they're considered them to be high risk. Do you have any advice for this particular scenario?
Sure. Okay, so that's a rather complex question. You're right. Generally speaking, employers have a work health and safety obligation to ensure the safety of all their employees. So that's block one. Block two is if the employee is living in an LGA of concern and working in that same LGA, then the public health order does not apply. So it may be that the employer may want to consider alternative duties for that particular employee. Can he segregate this particular employee from the rest of them? Ultimately, however, the other employees who have an issue with it, they can't really dictate to an employer how they wish to work either. It is rather complex, and it is something that may require further analysis. Is this something that he and I could speak about? Because I do not want to rush an answer in this regard.
Yeah, I think certainly if they've listed themselves as an anonymous attendee, so if you wouldn't mind perhaps just emailing myself or Chinthana after this, and we can
yes,
that discussion up. Look, there are a lot more questions coming through, and we still have about 100 people online. So if you're happy to stay just for a little bit longer and perhaps
sure,
get a couple more of these, are you happy to do that?
Yeah, absolutely.
So this one is from Lyndall Mitchell. If a worker cannot work from home and is legally obliged to stay home due to being a casual contact or waiting for a test result, are they obliged to take sick leave? If not, what kind of leave will they be paid if they're obliged to stay home?
Well, if they're obliged and they can't work from home,
they can't work from home.
Right. Well, in that case, they could take leave to the extent that they have any leave. Or if they don't have any leave and they've exhausted their sick days, it may be at the employer's discretion to cover that. But again, that is not something that I have particularly dealt with at the moment.
Also, it's Gina Field from Nepean Regional Security with that question. So certainly I can connect you with Gina after the call. There is one here. So you mentioned that where there is a high level of interaction with the public, vaccines can be encouraged. So this particular inquiry is from the tourism sector. Mm-hmm. Once we reopen our doors to the public, is it considered lawful to encourage our employees to get vaccinated in this case? Because they are interacting with a lot of...
Sure. There's nothing preventing you from encouraging your employees from getting vaccinated. The issue arises when you mandate that they do so. So encouraging people, putting up posters in common areas, for example, that say, I don't want to call them motivational posters, but posters about information about the vaccine, where they can get it, etc., aren't unlawful. I mean, you can certainly do that, but the ability of an employer to mandate, to essentially direct an employee to get a vaccine, will depend on the number of circumstances.
That one's a bit of a long one, so I might leave that one for the minute. I think it's going to be so this one here I think it's very complex. The answer will be for this one. So what about the requirement for people to visit hairdressers, cafes, only if they're vaccinated, which is obviously what the Premier has been talking about, most likely at the conference and continually over the past couple of months. Is that a violation of human rights?
Right. So I am not a human rights lawyer, and I would be very hesitant to comment on an area of law that I am personally not involved in. So I think that question is better directed to a practitioner in that particular area. I wouldn't want to provide this person with the wrong information.
And this final question, we might leave it after this, from George. From a legal standpoint, why does it matter if you reside in a known LGA area of concern or not? I have an employee who needs to be vaccinated under health orders, but this would not apply if she was outside of a known hotspot.
Sorry, could you repeat the question? I didn't quite catch.
Yeah, I'm not sure I understand either. So from a legal standpoint, why does it matter if you reside in a known LGA area of concern or not? This person has an employee who needs to be vaccinated under the health orders, but this would not, so she wouldn't need to be vaccinated if she wasn't in an area of concern, I'm guessing.
Right. So that's more of a policy question, really. The public policy, from what I gather, is that there are certain LGAs of concern, obviously, that have a higher number of infected people. I, for example, live in an LGA of concern. And the government, in an effort to control this particular outbreak, the Delta variant, which is far more infectious, have focused on certain LGAs where this variant has run rampant. And I think that is the reason why they have essentially differentiated between LGAs of concern and non-LGAs of concern.
And obviously the health orders change everything.
Yes, they do. And they can change frequently. Yes, that's right. Yeah.
All right, well, that is all we have time for, and thank you for staying that little bit extra to get to those last few questions. I think
no problem at all. And please do contact us if you have any further questions. More than happy to take this offline.
Terrific. Thank you very much. And thanks to you also, Jeff, for your presentations. It was really informative, and we're getting some really great feedback coming through at the moment from those that are still online. And also thank you to Jeff and the team at Matthews Folbigg for making available those special offers to assist small businesses and our members in preparing the various letters and whatnot for debt recovery. So for information on upcoming events or the many benefits of becoming a WSBC member, including connection, business support, and promotion, obviously, of your brand in WSBC, in Western Sydney, please visit our website, wsbc.org.au. Thanks again to Jeff and Chinthana and the team at Matthews Folbigg for today's wonderful presentation. Have a great afternoon and stay safe.
Thanks, Amanda.